Hi, I'm Jason Sullivan of Rathbone Group, and this is On Subrogation. In this video, I'll tell a little story about a client that sent a file to our office where they thought they had a settlement agreement, but the other side hadn't sent the money. What happened was our client had a claim where the other carrier clearly admitted liability. There were no questions about that. They did send over an offer to our client. It was based on a pro rata offer of the limits, and so it was less than my client's full balance. My client had clearly tried to collect that excess amount from the underinsured tortfeasor, and when they weren't able to successfully accomplish that, about a week before the statute of limitations on the underlying negligence claim expired, they sent the signed release over to the other side. That other side had previously sent their offer, the pro rata offer, along with a release. So my client signed that release, emailed it back to the other carrier, and then the check never showed up. So my client was a little frustrated. Why wasn't the check received? They had signed and sent over the release, and then the other side said, well, we never got the release, so we're not paying. So what's the solution to this situation? If you've come across this where you thought you had an agreement and suddenly the other side's refusing to pay, what do you do about it? And the legal analysis for this situation really goes back to Contracts 101. If you're studying for the bar exam or you ever took the bar exam, this may be a familiar situation to you. And the reason for this is, in order to have a valid and binding contract, you have to have a couple of things: offer and acceptance. So in this case, the offer is clear. A party says, yes, our insured's at fault. We want to resolve this claim. Here's what we're offering to resolve the claim with you. Now, once that offer has been made, it's up to the offeree, the person receiving that offer, on whether or not to accept it. And if they accept it, they then have a binding contract. But in order for acceptance to apply, there's a couple of things you have to keep in mind. One is the mirror image rule. If an offer is made, it's not accepted unless the mirror image of that offer is accepted. So if you receive an offer for $10,000 to resolve a claim, subject to a release that includes indemnity and confidentiality language and other terms that your company is just not going to accept, and you reply and say, we'll take the $10,000, but no indemnity and no confidentiality, is that a mirror image? And the answer is no. You've got three things on this side and one thing, and then two things crossed out. So it's not the mirror image. So whenever you're responding to an offer, always make sure that it is a mirror image of what is being offered. Otherwise, you may not have acceptance. At best, you're going to have a rejection and then a counteroffer that the other side may agree to accept. They may say, okay, we'll still pay the $10,000 and we don't need to have the indemnity or the confidentiality. Now you've made the offer and they've accepted, and that would be the mirror image. The second thing to consider is also timeliness of the acceptance. So in cases where the offering party puts a deadline on acceptance, that's going to govern when the offer can be accepted. So you may receive time demands from personal injury attorneys all the time. We demand that this be settled for $250,000, and this offer expires on the 31st of this month if we don't hear from you by 5 p.m. Well, if you look at that and then get to them a week after the deadline, that's no longer acceptance because they put a time amount on that and you didn't respond within that time, and that offer dies. And I can very clearly remember from my Barbary course that I was studying almost 20 years ago now. And that professor who was teaching the course said, once an offer dies, it's dead, and we don't touch dead things. So when that offer is extended to you with the time limit that it must be accepted by this date, and then you don't accept it, that offer is dead, and you can't go back and accept it. Now, if there is no time limitation, the courts look at whether or not the time in response was reasonable. And this gets very case specific and really hard to say if there are any rules because you have to look at everything and determine whether or not the timing of the response was reasonable. If you are pursuing a subrogation claim based on negligence, at the very end of the reasonableness spectrum, I think you're going to find the statute of limitations on the underlying claim. So if you have an offer to resolve the claim and you don't accept that offer and then the statute of limitations expires, I think you're going to be hard pressed to find a court that says that that later acceptance was good enough. It was no longer reasonable and it was outside the deadline. Another final third thing to consider for the acceptance is that the acceptance must be made in a reasonable manner. Now, when you're working with insurance company to insurance company or insurance carrier to trucking company, everybody communicates by email. Maybe some people still use fax or letters in the mail. So as long as you're responding in a kind manner, that's going to be a reasonable response. So if you get an offer letter and you reply in writing, that would be reasonable. So let's go back to the case with my client that had received an offer, had waited until just before the statute of limitations, had sent back that offer, and then hadn't received payment. So the offer is clear. There was a clear offer, and when my client signed the release, they didn't make any changes, and they accepted all the terms, so we have mirror image, so we're okay on that. They emailed it back to the other carrier, and there had been lots of email correspondence between the two carriers, so that type of response was certainly reasonable. So now we get to the key thing, timeliness. There was no time demand on the reply, so my client had a reasonable amount of time to reply, and I would argue that their response was timely, and it was made before the statute of limitations. But now we come to this issue that the other carrier claims they never got the signed release back, so there was no deal. And this is where the dispatch rule comes to save the day. The dispatch rule basically says that an offer can be accepted and is accepted at the time that the accepting party puts the acceptance in the mail, or for modern times when they email it or fax it or send it back in some other manner. So the fact that my client accepted and signed the release and then emailed it, even if the other carrier didn't receive it for whatever reason, that was a valid acceptance based on the dispatch rule. Now, of course, there are exceptions to the dispatch rule, and there are all kinds of situations where it doesn't apply. But generally, for your subrogation matters, that is going to apply. If you put something in the mail and you send it to them, even after you send it, if they rescind the offer or pull it back, there's a valid agreement based on that dispatch rule based on when you put it in the mail. So I reached out to the other carrier. I provided them proof and an affidavit that the release was sent back to their company on such and such a date before the statute of limitations. And in order to avoid a lawsuit for a breach of a settlement agreement, the other carrier agreed to pay. So good for our client, good for the win. Important things you should remember about this, though. You don't have an agreement until there's an offer and an acceptance. And the acceptance must be the mirror image of the offer. I see a lot of releases where things get crossed out, and that's not mirror image acceptance. And so if you do that, you do risk losing that offer because that offer's been rejected, it's dead, and we don't touch dead things, so that offer no longer exists, but now you've made a counter offer that the other side is free to accept if they choose to do so. Also, the moment you send that acceptance, now you have a binding agreement. And finally, when you're making these communications, make sure it's in writing. Certainly, my client could have called and said, hey, we accept your offer of $10,000. Please send us the check. Now, they wouldn't have had the writing or the proof that that was sent to the other carrier, so they wouldn't have been able to avail themselves to the dispatch rule if the other side denied ever receiving that call or that voicemail. So while the phone is a great tool to negotiate and discuss, I always recommend confirm things in writing. If you get an offer verbally, send back that acceptance in writing, confirming that, hey, you made this offer on this date and our client accepts, because now you've got a written record that you can rely on to help prove your case. For On Subrogation and Rathbone Group, I'm Jason Sullivan, and that's the long and short of it.